question is, what exactly must be the entry for sex in the civil register for births? And the answer, no authority best answers our question than the law which requires such entry. And I speak of Act number 3753, also known as the Law on Registry of Civil Status. In Section 5, it is subtitled Registration and Certification of Births. And Section 5 gives us the answer. The entry must be sex of infant. The law is clear and leaves no room for construction. When it refers to sex as an entry in the civil registry, it refers to the sex of the infant. Your Honors, the respondent wishes to use Rule 108 to effect the change of entry. But the question is Rule 108 applicable to his case? And the answer is no. Rule 108 is entitled Cancellation or Correction of Entries in the Civil Registry. For an entry to be corrected, it has to be in error. But the respondent never disputed the fact that his sex at birth was male from the very beginning. And therefore the entry in the civil registry has always been correct and did not be changed. There was no error, there is no need for a correction. Your Honors, the respondent, because of sex change operation, claims that he is female. But the question is he a female? The more precise medical term used is not sex change operation. It is sex reassignment surgery. This procedure composes of 10 complex steps. Its objective, to reshape the penis to look like a vagina. If this court has the opportunity to examine the respondent's organs like now, this court will be confronted with unsettling realities from his perversion. The organ he calls vagina does not contain vagina tissues. These are bits and pieces of tissues from the skin of his penis. The organ he calls labia does not contain labia tissues. These are bits and pieces of tissues from the skin of his scrotum. And if this court will look closer, this court will note that the respondent still has his prostate gland intact, so that he will feel the spasms experienced during orgasm. Can he reproduce? Definitely not. Not as a male because he no longer has his testes. And neither can he reproduce as a female because he doesn't have uterus or ovaries. He remains a male without the capacity to reproduce. His genitalia might have changed in form, but its substance remains the same. Your Honors, if we allow the change of entry as the respondent wishes, then we allow through remedial law what is not allowed by substantive law. The Family Code describes or defines marriage as a special contract of permanent union between a man and a woman, entered into in accordance with law for the establishment of the family.
Counsel,
Yes.
stating with definiteness the definition of a male and a female.
Your Honors, it is admitted that there is no law defining what is male and what is female. Because from the very beginning, it is nature itself which defines what is male and what is female, and that is determined at birth. May I proceed, Your Honor? if we are going to give force and effect to the provisions of the family code, when we mean woman, we mean in the ordinary sense, a woman, a person with a natural capacity to reproduce, that which belongs to the female species, with capacity for procreation and rearing of children, abilities which are completely absent to a transsexual female. Your Honors, if we allow the change of entry, we will remove all impediments for the respondent to marry a person of his own kind. And the family code definitely prohibits marriage of the same sex. Your Honors, the petitioner, the Republic, prays for this court to declare that the sex of the respondent remain male despite sex change operations or sexual orientation, and to deny his petition for a change of entry in the civil registry. All being said, the petitioner rests its case for the decision of this honorable court.
I have one question to ask the counsel. You mentioned about a female as one who is able to reproduce.
Yes, Your Honor.
Have you come across any thing, a case of anyone in the series of so many laws that we have in this country, with the possibility that so-called female may reproduce, that so-called apostrophe female could reproduce? If you would be lurking on the idea that a female is one who is able to reproduce.
Your Honor, the family code defines marriage for the establishment of a family. Your Honor, when we say family, we mean a father, a mother, and children. And therefore, if a family is to be established, it is a natural consequence of reproduction. Therefore, I cite the family code as pertaining to reproduction, Your Honor.
Counsel, you argue that you will not allow the change in the records on the ground that he is by nature a male, and if we allow a change in the entry, he will not possess all the capacities of a woman, including rearing of children. Are you saying that a woman who is not capable of rearing children will not be considered a woman?
Your Honor, if because I was flashed 1 minute, if your honors will permit me to continue an extension to answer the question. When I said reproduction, I mean a capacity to reproduce. Not necessarily that the woman is actually able to reproduce, because by nature alone, a woman in the ordinary sense, without the interruption of artificial means, can reproduce, Your Honors.
Precisely, you're saying artificial means. You have made assumption of facts. What if through that transsexual, how do they call this? Sex change, through modern technology, we are able to allow a person to reproduce, a male to reproduce as a female. Will your argument now change?
Your Honor, current state of technology does not allow the production of transsexuals. And the issue at bar is whether we're going to allow the change of entry right now. So, Your Honor, we stick to our position that the entry must not be changed. And since it is a hypothetical question, that would be tackled in appropriate proceedings, Your Honor. Your Honors.
May we now hear the arguments of the panel.
Madam Chief Justice, Your Honors, the counsel now stands before you as the counsel for the appellee. May it please the court. The appellee firmly stands that the court should allow the corresponding alteration of entry of sex on the basis of sex reassignment surgery and the so-called sexual orientation of a petitioner because it has been protected by the Constitution itself. If I may cite Article 2, Section 11 of the 1987 Constitution and Article 22 of the Universal Declaration of Human Rights, as have been indexed in our pleadings. In Article 2, Section 11, it states that the state values the dignity of every human person and guarantees full respect for human rights. Human freedom, Your Honors, and human dignity means that a man is free to shape what best fits his personality. He is free to develop your personality, and the society cannot circumscribe the limitations of your capabilities. And the Constitution also states that it shall promote a just and dynamic social order. Being dynamic, if it may please the court, I will quote the Advocate General in one of the cases we have indexed in our pleadings. The Advocate General stated that the law cannot cut itself off from society as it actually is, and it must not fail to adjust as quickly as possible. Otherwise, it will risk imposing outdated views and taking a static role. And it also, in the Universal Declaration of Human Rights also states that we have freedom to participate in cultural life, share in scientific advances, and become a member of society and realize our social and cultural rights. But since this case is a case of first impression, I know that all this foreign jurisprudence is not automatically binding upon in our courts. But since there is no law that defines what male or female is, the court should still render judgment. If jurisprudence or law, specific laws are not available, then of course, we must use the rule of equity and also other secondary sources of law. The International Bill of Gender Rights also states, which was adopted in June 17, 1996, that we have the right to control and change our body cosmetically, chemically, and surgically in order for us to achieve a self-defined gender identity. And we cannot be denied of these civil or human rights. And reproduction is not the sole basis of being a female or a woman. The European Convention on Human Rights also emphasizes the protection of personal identity. And it is our firm stand that the state, since this is a case of first impression, must make means in order to understand this human condition. And I refute the appellant's contention that gender identity, there have been gray areas about it. That it is not a matter of choice. That it has already been evident even before puberty, although the causes have not been specifically determined. If the court would allow the corresponding change, it will be a signal to society at large that transsexuals, as we may call it, are to be treated the same, equal, as if anybody else, according to the color of law. But if we will disallow the prayer of the appellee, the mere fact that the law has already marginalized these type of people signals to society that there is an oppression of law. It signals to the public that it is acceptable to discriminate and mistreat them. Because as we all know, the birth certificate is of primordial importance in our everyday life. Passporting, marriage, enrollment. And now, if physically, okay, and by your if physically you are already changed or you have undergone the sex change and your birth certificate states that it is male, indeed, it will be implied that in one way or another, there will be discrimination. And we all know that the birth certificate is only a prima facie evidence. It is a document of historical facts and not of current identity. And if sex is indeed determined by birth, okay, that means that citizenship also should be determined at birth. But the law allows, okay, that even after birth, you can change your citizenship. Of course, with certain limitations. And if I may state that the body alone is not the determination of sex. Because the law does not define what male or female is, okay, we must resort into other jurisprudence. And if the court will permit, I will proceed to our third claim. Then, since there is no law that prohibits sex change, then the new legal sex must be impliedly allowed because it has been the norm of majority of the countries. If you bring your attention to our Annex A1 and our Annex A2, it will state that 23 out of 37 member states of the Council of Europe permitted sex reassignment surgery and also fully recognized sex changes, okay, in the birth certificate. That was in the year 1997. 59% permitted the changes. 31% of the member countries were unclear. And only a meager 10% prevented the change in civil status. And it is worthy to note that those who did not permit the change in civil status only based their decision not for reasons of administrative convenience or consistency, but on the basis of fundamental moral objectives. And if I may be given to wrap up the whole claim of the appellee's side. As I have read in the Reader's Digest, November 2004 edition, it has said that all of us are writers and our lives are open books. Each and every relationship, and in this case, each and every case that this court has the opportunity to decide on is a chapter. And it's up to us to make sure that as writers, that the characters are worthy of inclusion. But the catch, Your Honors, is that unlike a book on a paper, we cannot have any way to edit out the bad choices that we have made because this is a life we are talking about. But the most important thing about all of this, Your Honors, is that we still firmly hold the pen in our hands. And as writers, we decide the ending of the story. And since the state is like every other parent, okay, who takes care of his child, our only hope as parent is that our child's story would lead into a happy ending. And I hope, Your Honors, that this will lead to a happy ending. And you too, Your Honors, will share the sentiment as we have. Thank you.
Counsel. In this petition, you are invoking Rule 108, Section 2, which provides that cancellation or correction of entries may be made in cases of births.
Yes,
Is
Your
that right?
Yes, Your Honor.
How can you now argue, considering that the sex change was made several years after birth? At the very first instance, at the birth of the child, there was no error.
Yes, Your Honor.
There was no error in the sex or gender of the person.
If the court will allow, I was given a 1 minute. I
Yes,
will
yes.
It is admitted, Your Honor, that at that time, there was no error in the entry of sex. But it is our stand that when the entry was made in the birth certificate, there was no process or medical fact that determined the gender of the sex. It was determined implicitly, okay, by prediction, which means that when it has seen that the sex of the child is male, it presumed by implication and by prediction that it will also have the psyche of a male. Now actually, in this court, it's...
The question, counsel, is this. Would you agree with me that Rule 108 presupposes